This is Lori Noreen Daybell's direct appeal from the district court's judgment, imposing a controlling term of life in prison without the possibility of parole for her convictions on 2 counts of first-degree murder, 3 counts of conspiracy to commit first-degree murder, and grand theft, and 1 count of grand theft. Okay, this is going to be really interesting. This is a Lori Daybell appeal. Now, of course, we're covering the Arizona case. This is in Idaho. This is interesting because of the Arizona case, but also remember, we are waiting to see what Sarah Boone tries. We get a look into one of these appeals right here. I want to give a real quick shout out to Tanika's 2 cents. I knew this document existed. I had a problem finding it. I couldn't find it on the Supreme Court of Idaho's website, and she gave me the link so we can cover it. Ms. Daybell respectfully contends several prejudicial errors tainted the fairness of the proceedings in the district court. 3 appellate issues surround the district court's mishandling early in the case of the state's quest to remove Ms. Daybell's retained attorney. First, on the merits, the district court's ruling disqualifying Ms. Daybell's attorney violated her fundamental Sixth Amendment right to counsel of her choice. Second, the court deprived Ms. Daybell of her Sixth Amendment right to the assistance of counsel at a critical stage when it erroneously routed the disqualification issue into the companion case of State v. Chad Guy Daybell and did not allow her counsel to intervene on her behalf in that case. Third, the court violated Ms. Daybell's 14th Amendment right to due process of law when it heard and decided this issue while Ms. Daybell was incompetent. Her case was stayed, and she was not present. The district court also erred in permitting the state to present wide-ranging, uncharged, bad acts of evidence at trial under Rule 404B. You've heard 404 a lot on Friday, but this time of the Idaho Rules of Evidence, which injected prejudicial character and propensity evidence into the case. And finally, the trial never should have happened because Ms. Daybell's right to a speedy trial was violated. Remember, in Arizona, she's constantly saying, no delays, no delays, no delays, family tragedy, gotta get it through. This court should reverse the district court's judgment on any of these grounds. Let's begin with the statement of facts. In 2018, Lori Vallow lived in Arizona and was married to Charles Vallow. Lori and Charles had adopted Charles's grandnephew, Joshua Jackson, was born prematurely and was autistic. He was smart and loving, but he was also a typical 7-year-old autistic kid, meaning he followed a strict routine and had some trouble in social situations and could get upset at small things. He was not yet fully potty trained at night, and he attended a private school that had services for autistic kids. Lori's daughter from her previous marriage, 16-year-old Tylee, also lived in the home. Tylee was a smart and vivacious kid, but she could be a moody teen. Tylee struggled with depression, anxiety, and panic attacks and had frequent and painful bouts of pancreatitis throughout her childhood. Tylee got her GED so she could graduate from high school early. Lori's faith was a central component of her life. She was a devout member of the Church of Jesus Christ of Latter-day Saints. In October of 2018, Lori met Melanie Gibb at a church event and they became friends. They talked on the phone and texted each other. Another member of their circle was Zelima Pastenis. Melina and Zelima had been routinely attending Preparing a People conferences. Preparing a People was a group or association that sponsored periodic conferences and events with speakers who would teach attendees how to better prepare for anything that might happen like a disaster, but as well as preparing them for the second coming of Jesus Christ. Melanie and Zelima shared these interests in common with Lori along with other individuals in their circle of friends. In late October of 2018, Melanie, Zelima, Lori, and 2 other women drove to St. George, Utah to attend a conference. Chad Daybell from Rexburg, Idaho, was a frequent speaker at these conferences, where he would also sell his novels about end-time preparation, near-death experiences, and other spiritual matters. Lori had not met Chad before, but she had read a few of his books. Lori spent much of the weekend at Chad's table. Melanie claimed that Chad told Lori they had been married in an earlier time period. As part of their religious beliefs, Chad, Lori, and others believed that people had lived multiple prior lives or probations. Chad had also had a near-death experience from which he gained spiritual insight, as had Lori, and he claimed to be able to see beyond the veil. There was an immediate connection between Chad and Lori. After they met, Chad and Lori continued to contact and see each other. This was a difficult time in Lori's own marriage, which had started to deteriorate. By the early 2019, Charles and Lori had separated. Lori and Charles tried a brief reconciliation in Houston before Lori moved back to Arizona with Tylee and JJ. Chad taught the circle of friends that he could see light and dark in people and had developed a rating scale of lightness and darkness. After that, as Melanie and Zulema would testify at trial, Lori began to tell them that Charles was possessed by a dark spirit or a demon. They engaged in castings with her, or something akin to a prayer circle, where they would attempt to cast out Charles's dark spirit. On July 11, 2019, Charles came to Arizona to spend time with JJ. He arrived at his estranged wife's house a little after 7:30 a.m. to take JJ to school. Charles got JJ into his car when he realized he had left his phone inside. Isn't this not the story that the state gave in Arizona, and it was that Lori took his phone? Tylee was sleeping in her room, and Alex Cox, Lori's brother, was sleeping in another room. Charles came back inside to get his phone, but Lori had it. Charles got extremely upset she had his phone. They argued, and Charles started chasing Lori around the room to get his phone. Hearing the commotion, Tylee came out of her bedroom with a bat, which she poked at Charles to protect her mom. He took the bat from her. By this time, Alex had stirred and emerged from his bedroom to subdue Charles. Lori got Tylee out of the house into the car with JJ. Oh, so here's the description. This description primarily comes from Lori Daybell's statement to the police. The state would contend at trial that the actual shooting of Charles Vallow was intentional and not self-defense, but the initial events in the home were not really disputed. The way in which Charles was shot was disputed, however. I thought it was disputed that she took the phone from, he didn't just leave the phone in the house, that she took the phone. I thought that was disputed. I could be wrong. It's been a while. Alex claimed that Charles hit him in the head with the bat, so he went to get his gun. He came out of his room with the gun, Charles approached him with the bat, and Alex shot him twice. Police officers would later testify that some of the physical evidence did not match Alex's version. Charles died from his wounds. Because of Charles's death, JJ began to receive Social Security benefits as Charles' surviving minor child. Lori checked into Charles's $1 million life insurance policy and discovered he had changed the beneficiary to his sister. On September 1st, Lori moved from Arizona to Rexburg with Tylee and JJ. Alex also moved to Rexburg. Lori lived in an apartment and Alex lived in another unit in the same complex. Lori's niece, Melanie Pawlowski, whom she considered to be a daughter, came to Rexburg and lived in the same apartment complex. Melanie, who was divorcing her husband, Brandon Boudreau, was part of the same group of friends as Lori. Like how we're just skipping the murder attempts. Lori enrolled JJ in a local elementary school. Tylee had finished high school and was living at home for the time being. On September 8th, Alex, Lori, and the kids went to Yellowstone National Park. Lori took a picture of a smiling Tylee hugging JJ with Alex on the side near some of Yellowstone's famous geysers. Actually, I guess they haven't had the murder attempt yet. On September 20th, Melanie Gibb and her fiancé David Warwick came to Idaho for the weekend to visit Lori. Melanie and Lori were also attending to record a podcast. Melanie and David did not see Tylee while they were there. They did interact with JJ, however. They would later testify that on the evening of September 22nd, Alex came inside holding a sleeping JJ, taking him upstairs. Late into the evening, Melanie and Lori recorded their podcast, with David also preparing. The next morning, David and Melanie left to continue their trip. They did not see JJ. JJ did not return to school. In early October, Chad's wife, Tammy, was in her driveway, having just gotten out of her car, when a masked person approached and fired what appeared to be a paintball gun at her. She asked him what he thought he was doing, and the person ran away. Within a few days of that event, someone fired a gun from the back of a Jeep at Melanie Pawlowski's soon-to-be ex-husband. Bandon Boudreaux in Arizona. So there's a shooting. The shooter missed him and Brandon stepped on the gas. This incident became part of the state's case at trial under IRE 404B. This is where it's really interesting, where if you are actively watching the Arizona trial, we are doing that Brandon trial right now. And that's what is being brought up here. On October 19th, Tammy Daybell died suddenly, ostensibly in her sleep. The coroner initially ruled the death to be natural. Chad chose not to have an autopsy completed, and Tammy was buried in Utah within a few days. He collected life insurance for her death. On November 5th, Chad and Lori were married in Hawaii. In November, JJ's grandmother contacted the police seeking a welfare check because she had not heard from her grandson in quite some time. The Rexburg police contacted Lori at her townhome. She told them that JJ was with her friend Melanie Gibb in Arizona. The police contacted Melanie Gibb, who shared that she had him, but then she didn't have him. Anyone that Lori had him right anymore. She then called them back and told them that JJ had never been with her. After this encounter, Lori and Chad left Rexburg and went to Hawaii. In the meantime, Alex Cox had married Zulema Pastenes. He moved from Arizona to live with her. On December 12th, Alex died. There is no evidence that foul play was involved in his death. Tammy's body was exhumed and examined. The coroner revised cause of death to asphyxiation. The children's whereabouts continued to be unknown, and law enforcement testified their investigation on September 20th, 2020. Police officers arrested Lori Daybell in Hawaii on 2 felony charges of alleged desertion of her children, along with associated misdemeanor charges. She was extradited to Idaho to face those charges. So that is Lori's appeal rundown of the events as we approached trial. And then we get into their version of events of the court proceedings, right? The events leading to the district court's disqualification of Lori Daybell's retained counsel of choice. Immediately upon her return, Lori retained attorney Mark Means as her counsel, with Chad supplying the funds to hire Means. Means entered his appearance as Lori's co-counsel in the desertion case. Means would eventually be her sole attorney in that case. Around that same time, Chad retained John Pryor to defend him against any forthcoming criminal charges. Pryor took the place of a previous attorney that Chad had retained, but who did not intend to represent Chad if a criminal case came to fruition. Smart choice. Several weeks after Means entered his appearance on April 28, 2020, he issued a press release that he represented Chad and requested the media to please direct all requests for communication, statements, and the like to his office. He posted a similar message to his Twitter account. That same day, Lori called Chad from a jail phone. In that call, Chad indicated that Mark Means currently represented both Lori and him to some extent, although Chad told her he was eventually going to go with the other guy, meaning John Pryor. At Lori's bail reduction hearing, Means informed the judge that he represented both Lori and Chad. Within 6 weeks, on June 2nd, 2020, police searched Chad's property and discovered the bodies of the missing children buried near a pet cemetery in his yard. While the search was ongoing, Chad attempted to drive away from the scene but was arrested. Based on the evidence found during the search of the Daybell property, the state charged both Chad and Lori with conspiracy to alter or destroy evidence. These were the first criminal charges against Chad. Means began appearing as Lori's attorney in her case. John Pryor now appeared in Chad's case as his counsel. The state's first attempt to remove attorney Mark Means. Isn't there going to be a conflict of interest even if he's not representing Chad actively because Chad is paying? Maybe I'm wrong there, legally. At Lori's initial appearance on the destruction of evidence charged in June, the judge asked Means whether he represented any co-conspirator listed in the complaint, and Means responded that he did not. The state moved the court to deny Means entry into the case and to appoint new counsel for Lori, arguing that Means had a potential conflict of interest after previously holding himself out as counsel for both Chad and Lori. In support, the state relied on the public statement that Means had made in April and May of that year, indicating he represented both Lori and Chad. It also pointed to the April 22nd recorded jail call between Lori and Chad, in which Chad suggested that Means represent both of them at the time being. Means countered that he had at most represented Chad in a limited capacity for a brief period before he had been charged. He reasserted that Chad had separate counsel in criminal matter, John Pryor, who had also informed the judge on more than one occasion there was no conflict of interest, and even it had been waived through a written waiver signed by both Chad and Lori Daybell. Means provided that written waiver to the judge. Means further claimed that he had consulted with the Idaho State Bar Council, who described the relationship as limited representation or having a cup of coffee with Chad Daybell, and that representation, if any, ceased the moment Mr. Daybell retained Mr. John Pryor. The judge held a hearing on the issue and inquired of Lori whether she had reviewed and signed the written waiver, and she waived any conflict again on the record. She indicated she had, as did Chad at a later hearing. The judge concluded that while Means had represented both Chad and Lori before Chad was charged, creating a conflict of interest, both Lori and Chad had knowingly and voluntarily waived the conflict. State charges Chad and Lori Daybell in a single indictment, but the court separates the cases for pretrial purposes. Some 10 months later, on May 25, 2021, the state charged Lori and Chad with murder, conspiracy to commit murder, and theft. Although the state charged both defendants in a single indictment, the district court assigned 2 case numbers. This decision would have lasting implications moving forward. Ms. Daybell is found incompetent to proceed. Before Lori was arraigned on the new charges, the district court found her mentally unfit to proceed and suspended her case. It remanded Lori to the custody of the Department of Health and Welfare for competency restoration, where she would remain ongoing treatment for the next 10 months. The court ordered that all proceedings in her case were to cease in her case except matters related to the competency issue. Roughly, contemporaneously, Mark Means filed a notice of appearance as Lori's counsel in the murder prosecution. He now represented her in all 3 cases against her. Given that the death penalty was an option, the court appointed a second counsel for Lori, Public Defender Jim Archibald. State's second successful attempt to remove attorney Mark Means. While Lori's case was stayed, the state revived its attempt to disqualify Means based on his alleged brief simultaneous representation of Lori and Chad before Chad had been charged over a year earlier. The state filed this motion under both Chad and Lori's case numbers. Perhaps in response to the state's filing of the motion in both cases, the district court entered an order reiterating that each defendant had a unique case and a unique case number. The court confirmed that the cases are 2 separate cases regardless of the single indictment, and that they will only be joined for a single trial. The court ordered the parties to file all subsequent pleadings in each case, captioned only that individual's defendant's respective case number and name. In the wake of that order, sounds like, I'm going to stop here and talk for a moment. It sounds like we are getting into issues where the cases stayed, but the cases are combined, but the cases aren't combined because there's 2 numbers, so you got to file it in both numbers, but technically filing it in both numbers could go against the order because of her competency. I think that's what they're going with. It's like a legal quagmire that maybe this exact scenario hasn't actually happened yet, and they're banking on getting a new trial over it. In the wake of that order, the court set a hearing on the state's motion to disqualify Means, but because it had stayed Lori's case, it set that hearing only in Chad Daybell's case. Okay. Mark Means filed a motion for intervention so that he could be heard on the issue of his own disqualification. In this motion, he argued he needed to present facts and events necessary to resolve the disqualification issue, which squarely impacted his client's interests. He also noted that Lori had a right to her chosen counsel of record, and the prosecution has taken a personal interest in obstructing her constitutional right. Mark Means and Jim Archibald were present at the hearing, as well as the prosecutors and John Pryor for Chad Daybell. Chad did not initially attend the hearing because, as Pryor indicated, I see no basis for the court to go forward on this conflict in this case. According to Pryor, this motion is more properly brought in the Vallow case. Pryor repeated this sentiment multiple times throughout the hearing. If the state wants to pursue this motion, they can pursue it in the Vallow case. I'm going to renew my objection. This is not part of this case, and it doesn't belong as part of this case. Acknowledging Pryor's concern, the district court noted that it's probably worth sorting out the issue at this point of which case we are hearing this motion in, but then quickly moved on to Mean's motion to intervene in Chad's case. Mean argued that state was circumventing the stay in Lori's case by arguing the motion to disqualify him in Chad's case. He claimed that he shouldn't have to file a motion for intervention because the motion is pending before both of the cases, but he needed to be able to express her objection going forward based on the stay that is happening as well as the other things that have filtered through in the discovery, and the court should consider in a motion such as this. While the state agreed with Means this was really a single case against both defendants, it disagreed with the court's order splitting them. It still objected to Means' request to be heard on the disqualification in Chad's case. This ends up getting her a new trial. Construing Means' motion strictly as one seeking formal intervention as a party, the district court denied the motion. It found that there was no authority allowing one defendant to enter as a party in another defendant's case, overlooking perhaps that it had artificially split the cases to begin with. I kind of agree, right? Like, they are ruling on him. He can't be in another party's case, but also it's the same case, and it's about him. This is a mess. This is an absolute mess. I think it's just a mess. Whether it's successful or not, I understand why they're going down this route. I always find it interesting with, like, when I hear about an appeal, I'm like, what's the appealable issue? I see this one. I see where they're coming from. I don't know if it'll work. I don't know if there's, like, precedent, but, like, that might, decide one way or another. You could expect it to go one way or the other. I'd be very interested if, like, lawyer or someone follows this that has, like, actual law experience. While the court allowed Means and Archibald to observe the hearing on the state's motion for disqualification, they were not permitted to participate. The state steered the direction of the hearing, which occurred on August 30th. It was continued to September 8th, 2021, to focus on Chad's rights to conflict-free counsel rather than Lori's right to counsel of her choice. At the hearing, the court admitted as State's Exhibit 4 a partial audio recording April 28th, 2020 jail call between Lori and Chad, in which Chad indicated to some degree that Mark Means was also his counsel at the time, but he was eventually going to go with other guy. Eventually, the court came around the state's view, noting that it needed to explore the nature of any potential conflict with Chad's personally. Pryor, again, suggested if the court wants to go on way of inquiry, that inquiry should probably take place in the Vallow case and not the Daybell case. The court took the matter under advisement. Within a few weeks, the court held an ex parte hearing where only Chad and John Pryor were present. There, Chad clearly expressed the view that he did not consider Mark Means to have been his counsel at any point. At that time, Means had made public statements about representing both Chad and Lori. Chad had hired Pryor, but did not necessarily want it to be known publicly that he had hired a criminal attorney. The court has granted appellate counsel's motion to order the district court clerk to augment state's exhibit. Since the other side has requested the district court to correct the exhibit, but the filing of this brief has not been done. Ms. Daybell will therefore assume, for present purposes, the district court's description of its call on December 28, 2021 memorandum decision order is correct, but reserves the right to amend her argument when the accurate exhibit is found and provided. Okay. Interesting. So there's an issue with an exhibit. In any case, Chad informed the court that he did not provide Means with any confidential information. He was worried about being exposed. To the extent there was any potential for a conflict, he consented to Means continuing to represent Lori. The court again took the matter under advisement. Ooh, sounds like it's getting spicier. While the motion for Means disqualification was pending, an issue bubbled up regarding Lori's communication with an attorney for the Church of Jesus Christ of Latter-day Saints. Means learned that a clinician at the state hospital had allegedly urged Lori to call the church to inquire about the possibility of attaining legal counsel paid by the church to take the place for appointed public defender, co-counsel Jim Archibald. I mean, that sounds improper, in my opinion. I really don't think that someone working at the state hospital should be giving legal advice. Um, is it illegal? I don't know, but it's improper, I would say. I don't like that. Oh, you're mental. Like they're arguing she's not competent to stand trial, right? So an incompetent person is having their legal defense possibly changed by a medical professional. Based on that, Means filed a motion alleging certain violations by the state, containing that Lori had spoken freely with an attorney for the church who had indicated he might help her find additional counsel, only to turn around and give the information to the prosecuting attorney. See, I'm not fully familiar with the Idaho case. Means issued subpoenas to various entities to get the bottom of the contact between the church and the prosecutor. The state responded by denying impropriety and claiming that the prosecutor had a very short conversation, about 1 minute, with an attorney at the law firm representing the church for notifying co-counsel Archibald of the contact. The Means allegations and legal machinations had clearly touched a nerve with the state, which again urged the court in its responsive filing that Means had unwaivable and unethical conflict of interest due to his past dual representation. The state further argued that Mr. Means' continued involvement in this case is inappropriate and creates issues for appeal. Creates issues for appeal, and here we are. Within a month of that dust-up, the court granted the state's motion and disqualified Mark Means as Lori Daybell's counsel, so he got removed. It concluded that Means had represented Chad at least some period of time, that the representation created a conflict of interest, and that the court would not honor a waiver because of the severity of the case. Lori Daybell was still in the state hospital. She was not permitted to choose her own attorney. And now she regains competency and demands a speedy trial. Ms. Daybell's competency was restored. By April 11, 2022, the district court lifted the stay in her case. She was arraigned on the charges, and the state filed a notice that intended to seek the death penalty. The district court appointed attorney John Thomas as co-counsel to Jim Archibald. At her arraignment, Ms. Daybell demanded her right to a speedy trial, a position that she reiterated repeatedly throughout the case. The case was set for trial the following October. Almost immediately, the state filed a motion to continue the case. Over Ms. Daybell's objection, the district court granted the state's request and reset the jury trial to begin January of 2023. In September, Ms. Daybell's counsel received information from a mental health professional that they believe required reinvestigation of her competency. They filed a motion to continue the trial and the toll deadlines for pretrial filings. At the hearing on the motion, Ms. Daybell expressly disagreed with the findings of the mental health evaluator and objected to a continuance. She told the court that she believed the assessment was an attempt to prolong the case and that I am unwilling to give up my rights to waive my right to a speedy trial. Nonetheless, the court granted a continuance and held a competency hearing in November, after which it again found Ms. Daybell competent to proceed. It reset the trial April 3rd, 2023, about 90 days later than the January setting. Ms. Daybell moved to dismiss the case, claiming that her speedy trial rights were violated. The court denied the motion. This is sounding really familiar because remember, she's already filed about speedy trial in Arizona. She's mad that there was a delay between the first trial and the second trial. She's trying to have the judge removed. I'm getting a pattern. I think her plan for all of her appeals might have been speedy. Oh, it wasn't fast enough. I think that seems to have been all she could go with. The district court grants the state permission to introduce widespread, uncharged bad acts evidence from Arizona in the Idaho trial. See, this would be interesting in a retrial, right? Because all of this would be presumably guilty charges by then. Like, I'm assuming she's going to be found guilty in the second case. First case with Charles Shardy is. Some 8 weeks before trial, the state filed a motion to introduce evidence under Rule 404B of the Idaho Rules of Evidence. In that motion, it listed the general nature of the evidence that it sought to introduce, which included some 27 categories of evidence related to Charles Vallow's death, Lori's previous husband's death, and other evidence. Miss Daybell's counsel objected that the state's motion failed to give them reasonable notice. They argued that the state intended to introduce an enormous amount of evidence from Arizona at the last minute, essentially another entire case or cases. The state has been hiding the ball on this issue for at least 1 year and 8 months and 16 days, the time between the grand jury indictment and the proposed date of the hearing. The court expressed some agreement the state's motion was overbroad and vague, which prompted the state to file an amended motion to introduce the 404B evidence. In the amended motion, it indicated that it intended to introduce evidence primarily related to the circumstances surrounding the death of Charles Vallow and the attempted shooting of Brandon Boudreaux, Melanie Pawlowski's ex-husband. The defense again objected, noting the enormity of the evidence and the burden it would put on the defense to investigate all those matters before a trial that was set to begin in a few short weeks. This also, I guess, makes sense when she's like, well, these witnesses have been subpoenaed before, and it was for the Arizona trial. The Idaho trial. If this was brought up in that trial, this makes sense. The court granted the state's amended motion with a few minor exceptions, and it concluded that the evidence related to the shooting of Charles Vallow, the investigator into the shooting, and related matters were permissible to show the defendant's plan, preparation, knowledge, or identity. It likewise allowed evidence of the attempted shooting of Brandon Boudreaux, as it also to show preparation, plan, knowledge, and or identity. It concluded that the probative value of the evidence was not outweighed by the danger of unfair prejudice. So, it's really interesting because in the Arizona trials, she's already convicted. In Idaho, they didn't use any of it. They've worked really hard to not use it. And then in Idaho, where she hadn't been convicted yet in Arizona, they were using it. I guess Arizona is like... I guess a worry in Arizona might have been, if we allow in the evidence from Idaho, she can argue on appeal that it's like a circular logic where Idaho used Arizona's uncharged evidence to get the Idaho conviction, that the Idaho conviction was then used in Arizona to get a conviction there, and therefore, if anything happens in Idaho, that means what happens in Arizona should be up for a new trial or something like that. I could see that route, and that's why the state's being so, but Lori's trying to push it. Lori wants the 404. I think she wants it. I think she wants it brought in because she'll use it for an appeal. Now, that this is giving me like a new, personally, I think a new insight into what she's doing. I think she wants it for an appeal. A lot of what she does makes more sense when I think about it that way. The district court strikes the state notice of intent to seek the death penalty based on its repeated discovery violations. Less than a month before the trial, the state dumped additional discovery on the defense well past discovery deadline. As was a pattern throughout the case, defense filed a motion to strike the death penalty as a sanction for the state's discovery violation. The court granted that motion. The court concludes here that an inappropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's January 2nd, 2022 notion to seek the death penalty will be stricken. Because Chad waived his right to a speedy trial, the court severed the cases and kept Lori's case on track for trial to begin April 3rd. The death penalty remained an option in Chad's case. The trial, summarized. Oh boy. So this is going to be Lori's appeal trial case summary. So this is going to be as best a light they can put on for the defense and as terrible they can for the prosecution. The trial proceeded as scheduled, lasting about 6 weeks with 60 witnesses. In addition to the basic historical facts recited in this brief, the state's case at trial relied on other circumstantial evidence, including cell phone geolocation data placing. Sounds familiar. Alex Cox at the burial sites. So Alex Cox being placed by geodata is also important in the other cases. In Arizona, they're very big. Evidence of text messages and emails exchanged among alleged co-conspirators, the witness testimony about Lori Chad's religious beliefs and statements, same we're seeing in Arizona. The defense counsel countered that there was no physical evidence tying Lori to any of the death, that the alleged conspiracy to murder anyone was entirely circumstantial, speculative, and the state was using prior bad acts to shore up the case and imply guilt. So, the defense was that the prior bad acts would be the Arizona thing she's now being found guilty of were being used to imply guilt in the Idaho case. The jury ultimately found Lori guilty on all counts. Wow, that was a lot shorter than I thought. The district court sentenced her to 3 consecutive terms of life in prison with no possibility of parole for the first-degree murder, 2 concurrent sentences for life without parole for conspiracy to commit murder, and concurrent sentences for 5 to 10 years in prison for grand theft. She now appeals. Of those 60 witnesses, the undersigned calculates that at least 19 testified in whole or in part about 404B evidence from Arizona. So they're saying roughly a third was actually 404B from Arizona. Again, this is why she's like, well, they got subpoenaed in Idaho. Issues presented on appeal. Lori Daybell was deprived of her Sixth Amendment right to counsel of her choice when the district court disqualified her retained attorney. Ms. Daybell was deprived of her Sixth Amendment right to assistance of counsel during pretrial hearings on the state's motion to disqualify her counsel after the district court denied her attorney's request to participate in those hearings. I'm trying to think how I feel about the issues. I mean, I'm going to say those are, I don't know if I would say I don't know if they're successful strong, but I would say that it makes sense why you would try those on appeal. Can they just do the cases without doing stuff that like that? I don't know. It felt like they had to have known at the time they were going to be doing this exact appeal, right? Like, I have to imagine the prosecutors knew this exact appeal was coming. Maybe that's why I'm frustrated. Ms. Daybell was deprived of her right to due process under the 14th Amendment when the district court held pretrial hearings that affected her substantial rights in her absence while she was incompetent. Could they wait, though? Because they don't know if she's... The thing is, at the time, they do not know if Lori is going to be deemed competent, right? And if you're operating off of that, and this man is tied to another case, what do we do about the other case? Can you proceed in the other case while this possible conflict of interest exists in a, at the time, connected case? It might have been the only option they could do. Arguably, I don't know. The district court erred in allowing the state to introduce evidence of uncharged acts from Arizona into the Idaho criminal trial under Rule 404B of the Idaho Rules of Evidence. So, with that said there, if she gets a new trial, if she were to get a new Arizona trial, literally everything so far, they can rerun the same trial and not have the issues. If she gets a new trial, they cannot have the same issues with the attorney, and then this wouldn't be uncharged bad acts. They would be charged and probably convicted bad acts in Arizona that aren't tied back to the Arizona case. So, in fact, them not having 404 in Arizona might help. The 404 evidence not being used in Arizona might actually end up being used and helpful in a Idaho retrial. And that makes sense why Lori would then try to get 404 evidence into the Brandon trial, because there's a chance that she knows that if she succeeds and it gets in there, she can then try to use the fact that it was used from that trial, if they use the Idaho trial, in her current trial. But I think the state would probably, if she opens the door enough, I think Trina K would probably focus on Charles Vallow, because it's why Brandon was, expecting her to do something. But if they focus on Charles Vallow, that is also a completely separated case from Idaho, and therefore, even though 404 evidence got brought in, it's Arizona 404 evidence that didn't touch the Idaho evidence, and therefore, if Idaho does a retrial, I hope that makes sense. I think maybe the Arizona cases are being done in such a way to shield them from the appeal in Idaho. Because if you use Idaho stuff in Arizona and something happens with the appeal in Idaho, could that happen with the appeal in Arizona? Could we have to redo all of this? Rambling a little bit, but I think that gets it there. The district court erred in denying Ms. Daybell's motion to dismiss based on violation of her statutory and constitutional rights to a speedy trial. Maybe I missed it. I haven't seen anything where it's like, oh, she's being abused, speedy trial rights. I mean, a lot of trials get delayed for very legitimate reasons, and everyone doesn't get off because of that. Lori Daybell was deprived of her Sixth Amendment right to counsel of her choice when the district court disqualified her retained attorney. And here we go. This is for the individual arguments. We can see what they're trying to say here. Introduction. A criminal defendant has a fundamental right under the Sixth Amendment to hire counsel of their own choosing, free from interference from either the state or the trial court. Ms. Daybell retained attorney Mark Means to represent her against these charges. The state moved to dismiss Means based on a purported conflict of interest. The district court channeled that motion into Chad Daybell's case, did not allow Means to participate in the hearing on this issue, conducted an ex parte meeting with Chad before granting the state's motion. This all happened in Lori Daybell's absence and while she was incompetent. That's a rough one. I mean, obviously, this is going to be their best way of wording it, but that's a rough one. That's a rough one. Yeah. Ultimately, there was no actual conflict of interest. Any potential conflict had been waived by both parties, and the district court erroneously based on Chad's rights to exclusion of Lori's right to counsel of her own choice. The district court abused its discretion in granting the state's motion, and this court should reverse. Standard of review. The district court retains the discretion to grant or deny any prosecutor's motion. I'm not going to read that part. I'm not going to read the standard of law. If you're interested in that, that's available. It's going to be a lot of case law and discussion here. The district court's handling of this issue was seriously flawed from the beginning due to its desire to split the cases in two for all pretrial purposes. It routed hearings on the state's motion to disqualify Lori Daybell's retained counsel to Chad Daybell's case number. As Chad's trial counsel John Pryor noted repeatedly, this was a matter that was best addressed in Lori's case after she regained competency. While Chad had an interest in the matter, the state and district could breeze by Lori's fundamental right to choose her attorney. Worse, the district court refused to allow Means to participate in these hearings, even though the precise issue was whether he had a conflict of interest and even though his client's rights were at stake. Again, that's rough. Meanwhile, Lori sat at the state hospital, incompetent to proceed and absent. Procedural errors are by themselves sufficient to warrant reversal, as Ms. Daybell argues in issues 2 and 3. Here, though, she challenges the district court's ruling squarely on its merits. The rights to counsel was a choice of fundamental. Deprivation of that right is a structural error not subject to harmless error analysis. A court that assesses whether to disqualify the defendant's chosen counsel may take considerable care in balancing the rights and interests at stake. Let's go find some non-case law here. The district court abused its discretion because it focused on Chad Daybell's right to conflict-free counsel to the exclusion of Lori Daybell's fundamental right to counsel of choice. It did not act consistently with the legal standards applicable on the specific choices before it. The district court's myopic approach is readily apparent in how it conducted hearings on the issue. Initially, the court appears to have been sensitive to the need to halt all proceedings in Ms. Daybell's case while she was incompetent. Its order indicated that all matters would cease except for those related to competency. The court's unusual choice to split the cases also suggests it was concerned about the need to cease litigation in Lori's case, while litigation would move forward in Chad's case. At the beginning of the hearing on the motion to disqualify, moreover, it hinted that an awareness of the problems inherent in litigating a matter in a co-defendant A's case that affected co-defendant B's substantial rights, while co-defendant B's case was stayed for competency. That's a lot of words, but yeah, it's a mess. Preliminary note is probably worth sorting out the issue at this point, in which case we are hearing this motion noting that the 1624 case, what I'll refer to as the Vallow case, is currently stayed and later queried, and so the issue now is we will probably hear a motion objecting to Mark Means representing Lori Vallow Daybell in case number 1624, and does not the court have the ability to consider in a separate defendant's case of 1623. Despite those early glimmers of recognition that it had a problem on its hands, it eventually decided the state's motion without input from Lori or her counsel. I would say this is, again, I think this is our strongest part in all of this. It's the strongest part because it's a mess, because there's so many different angles they can hit it from, and they just got to find the one that the appeal agrees with. Not that it'll succeed, but it's their best bet. Ultimately, the court was persuaded by the state that it must conduct an inquiry into this conflict with Chad. It continued down that primrose path by holding an ex parte meeting with Chad to inquire about the alleged conflict. This flawed process led to a flawed decision. In its memorandum decision and order, the court acknowledged that a defendant has a 6-minute right to counsel of her choosing, but it concluded there was an actual conflict of interest that could not be waived due to the severity of the charges in this case. It referred primarily to the magistrate judge's prior ruling finding an actual conflict of which it took judicial notice. The precise nature of the supposed conflict was never explained, however, presumably because one did not exist. See, that's going to be a thing. What was the conflict in words written out? If that doesn't exist, if there's not like an exact here it is, we're like, well, we infer they meant. That sucks. That's not very. As a layperson, it's like Mark Means did not currently represent Chad Daybell, so any duty of loyalty would arise only in the context of a duty owed to a former client. It is true that over a year and a half before the court's ruling disqualifying him in this case, Means portrayed himself as representing Chad before Chad had been charged, and at a time that he also represented Lori, but to the extent that he truly represented Chad in some capacity as attorney as for a matter of weeks, as bar counsel apparently told Means this was a cup of coffee that ended the moment that John Pryor was hired. The bar counsel's involvement also, I think, is a thing that needs to be thought about. I'm taking it as truth because I don't think they're going to lie. I don't think an appellate attorney is going to lie about that. Even assuming that Means represented Chad at one time, the heart of any conflict of interest is whether the attorney's representation would be materially limited by conflicting duties of loyalty to a current client and a former client. As applied here, an attorney in Means' position could have divided loyalties if he had learned something from Chad that would help his client Lori at trial, but he also still owed a duty of loyalty to his former client, Chad. What is woefully absent in this record, though, are any facts of which the court could rely to find that Means had such information or had some other material limitations moving forward. The best evidence on that issue came directly from Chad Daybell himself and is squarely contrary to the district court's ruling. During the court's ex parte colloquy with him, Chad unequivocally asserted he did not consider Means to be his attorney. Did you ever understand he was representing you? And the answer was never. More to the point, Means and Chad never discussed any confidential information. The court, without giving me any facts, just yes or no, at any point did you discuss with Mr. Means any of the factual details of Lori's case or the circumstances surrounding her case? No. Did you ever discuss with Mr. Means any facts from your own personal knowledge about anything you've been charged with or that Lori's been charged with in any of the cases? I would only say it was more court appearances is all he ever discussed with me regarding Lori. The court says, okay, could I? And the defendant says such as dates and that she would appear in court. The court, okay. So he mentioned to you when her court would be, and the defendant said yes. It sounds almost like they're going to put out that like he instead of being like an attorney, he was more of a contact, so they could like I wouldn't say keep in touch, but like know what's like going on with like when she appears in court. I don't know. Pryor reiterated to the court, he had repeatedly said, I don't see a conflict here. I don't see a problem. I don't perceive any issue with this. And frankly, Ms. Vallow has no information on Mr. Daybell that could cause him any concern anyway. I think that's a lie. I think that's a lie. I think she had plenty that could harm him. Chad also unequivocally told the court that he had no problem with Means continuing to represent Lori. While the district court noted in its memorandum decision in order disqualifying Means that he conducted this ex parte inquiry with Chad, the facts that the court learned from the inquiry did not make it into its ruling. Whatever else may have been said about whether Means represented Chad in some capacity, what Chad told the district court undermines the court's conclusion of an actual conflict of interest. There is simply no substantial and competent evidence supporting an actual conflict of interest in this case. Still, it is true that the Supreme Court noted in Wheat what a serious potential for conflict might be sufficient to warrant overcoming a defendant's choice of counsel and waive any conflicts. This court should now view Wheat through the prism of more recent cases on a defendant's right to counsel of choice, such as Gonzalez-Lopez and Lopez, which reaffirms the centrality of the right of the Sixth Amendment. Regardless, there was no serious potential for conflict here. In Wheat, the defendant was affirmatively seeking the substitution of an attorney the day before the jury trial, while that attorney was actively and contemporaneously representing two other co-defendants in a complex drug trafficking conspiracy. The attorneys involved with the other clients was deep, long-lasting, and ongoing. The judge intended to call one of them who had pled guilty at trial, creating a serious risk that the chosen counsel would need to cross-examine his own client. On those facts, the Supreme Court held that the trial was within its discretion to find a serious potential for conflict would arise during the criminal trial. Here, in contrast, if Means represented Chad Daybell, a disputed fact, it was superficial and brief. Unlike Wheat, this limited representation occurred before Chad was charged criminally, ending well over a year before the issue was raised in the present case and long before the trial was even on the horizon. And the only evidence that the court had before it, whether Chad had imparted any confidential information to Means, but he had not provided any such information, Chad had also retained his own criminal defense attorney prior, who had represented him for a year and a half. The entire fact-finding endeavor was tainted from its inception because of the serious procedural flaws in the inquiry. Lori was incompetent and unrepresented on the issue, so her wishes were not considered. None of that was true in Wheat. Any risk was mitigated even more because Chad and Lori clearly and expressly waived any potential conflict in writing. They have reaffirmed their waivers at the hearing in the destruction of evidence case in front of the magistrate judge. Chad reaffirmed it yet again in the district court case at the ex parte hearing. In short, the potential for a conflict of interest in this case was speculative, attenuated, and clearly non-existent, while the potential for a conflict in Wheat was immediate, probable, and serious. When competing constitutional rights are at stake, a court has a duty to accurately weigh the results, weigh the risks and balances, the importance of rights. Here, the district court abused its discretion by using a miscalibrated scale with a thumb on one side. It did not receive any input from Lori or her counsel, but more than that, the evidence of a potential conflict fell short of what was required to overcome a defendant's constitutional right to counsel choice. And this is the bottom here. For any other layer of protection was missing, and Lori was represented by two attorneys. There was one time in which Chad was to testify unlikely and speculative event. Lori's co-counsel, Archibald, would conduct the cross-exam. So, mentioning that there, that even in the worry of a cross, there was a second attorney. This case instead has hallmarks of what the court in Wheat acknowledged was a possibility. The prosecution may seek to manufacture a conflict to prevent the defendant from services of an attorney that the prosecution dislikes. It is true that Means engaged in unorthodox practices, perhaps even practices that were not necessarily helpful to his client. But some of those practices, including accusing the state of improperly through contact with the Church of Jesus Christ of Latter-day Saints, clearly ruffled the state. I mean, yeah, I think that was improper. The whole thing with the hospital telling her to contact an attorney and that attorney contacting the state, I don't care. That's just the whole thing. That's off. Was it off enough for a mistrial at the time? No. Was it off enough that it's off? Yeah, I think it's off enough that if I was the attorney, I would bring it up. The state repeatedly and vigorously tried to get Means dumped from the case. In an adversarial system, the court should look upon such efforts with a jaundiced eye. Ooh, we are, by the way, 43 pages in of 71. At the core of the Sixth Amendment is the right for the defendant, which she can afford private counsel or counselors willing to represent her, to decide who she trusts and who she believes will best represent her interests in court, regardless of whether that attorney is viewed by others as the best one for the job. As the Supreme Court has recognized, this right is grounded in the close working relationship between a lawyer and client, the need for confidence, and the critical importance of trust. Means was not on the roster of death-qualified criminal defense attorneys, but he didn't need to be. Neither was John Pryor, who represented Chad Daybell from beginning to end. Archibald was on the roster and was Ms. Daybell's co-counsel. The right protects the defendant's individual liberty and respects dignitary interests. I guess I was saying that right. It is not a right that is intended to ensure the best representation possible. In that way, it's similar to the right of self-representation, which almost never enhances the quality of representation at trial. That's a bit of a dig. That's a bit of a dig at Lori herself. Trying to find when we get out of case law here. Regardless of what Mark Means' idiosyncrasies were, they were the idiosyncrasies that Ms. Daybell chose. He was her counsel of choice, and the state had a burden to present extremely persuasive information in a reliable and adversarial proceeding of a serious potential conflict of interest before that choice should have been removed from her. It did not, and the district court abused its discretion in granting the state's motion. For all these reasons, the court should conclude the district court violated Ms. Daybell's Sixth Amendment right to counsel of her choice when it granted the state's motion for disqualification. Ms. Daybell was deprived of her Sixth Amendment right to the assistance of counsel during pretrial hearings on the state's motion to disqualify her counsel after the district court denied her attorney's request to participate in those hearings. Introduction. If this court disagrees with Ms. Daybell on the merits of the district court's disqualification ruling for any reason, it should still conclude that the procedure by which the district court heard and decided the motion violated Ms. Daybell's constitutional rights. Here, she asserts that the district court's ruling prohibited her counsel from representing her interests at the hearing on the state's motion, violated her Sixth Amendment right to the assistance of counsel at all critical stages of this prosecution. As with the first issue, this is a structural error that requires reversal. Standard of review. Ms. Daybell acknowledges that her counsel did not argue specifically that if the district court denied his motion to intervene, then his client would be deprived of her Sixth Amendment right to the assistance of counsel at a critical stage for his prosecution. Alleged constitutional errors during the trial that are not followed by a contemptuous objection must be reviewed under the fundamental error doctrine. The fundamental error doctrine involves a three-pronged inquiry to determine whether that alleged error violates the one or more of the defendant's unwavered constitutional rights, plainly exists, and was not harmless. The defendant bears the burden of persuasion on each of these prongs. The second prong requires the error to be clear and obvious, from the record including information as to whether the failure to object was a tactical decision. If the record does not contain evidence regarding whether trial court's decision was strategic, the claim is factual in nature and thus appropriately addressed via petition for post-conviction relief. Standard of law. Once the state has initiated adversary judicial process against the defendant, the Sixth Amendment guarantees the defendant the right to have counsel present at all critical stages of the subsequent criminal prosecution. The adversary process begins with an indictment of the formal charge. Critical stages of a criminal prosecution are broader than just the trial itself, as the accused is guaranteed that he need not stand against the state at any stage of the prosecution, formal or informal, in court or out, where counsel's absence might derogate from the accused's right to a fair trial. A critical stage is therefore any stage of a criminal proceeding where substantial rights of a criminal accused may be affected. Critical stages include, for example, post-indictment police lineups, arraignments, preliminary hearings, and sentencing. Prejudice is presumed when a criminal defendant has been completely denied the right to counsel for a critical stage because it is an error that contaminates the fairness of the entire proceeding and is not subject to harmless error analysis. Holding that absence of counsel at a victim allocation during the sentencing phase was a structural error requiring per se reversal. The state initiated adversary judicial proceedings against Lori Daybell when it indicted her on May 25, 2021. Mark Means formally entered his appearance as her counsel soon thereafter. Her Sixth Amendment right to the assistance of counsel attached to all subsequent critical stages of the criminal prosecution. The hearing on the state's motion to disqualify Ms. Daybell's counsel was a critical stage. It is irrelevant that those hearings were not held under her case number. The Supreme Court has held that a critical stage is any proceeding, formal or informal, in court or out, where counsel's absence might derogate from the accused's right to a fair trial. In Wade, for instance, the court held that the defendant was entitled to counsel's presence at a post-indictment police lineup. What matters is whether the proceeding is one in which substantial rights of a criminal accused may be affected, a hearing at which the court is taking evidence, hearing argument, and weighing whether to dismiss a defendant's attorney is surely one in which substantial rights of the criminal accused may be affected. Ms. Daybell had a Sixth Amendment right to counsel to represent her interests at the hearing. She did not waive that right, and she could not since she was incompetent. She might win this due to being deemed incompetent. That's only helping, right? Like, that only helps her in this appeal. So she meets the first element of the fundamental error test. The second part of the fundamental error review looks at whether the error is clear and obvious, meaning that the record must contain evidence that trial counsel's failure to object was not a tactical or strategic decision. Miss Daybell also meets this element. In fact, her counsel did object below and asked to be heard on the matter of the hearing. He claimed the state had taken a personal interest in his dismissal and was trying to circumvent his client's rights to counsel of her choosing. He appeared at the hearing and argued the state should not be proceeding with the issue in Chad's case. He perhaps mistakenly framed his request as one seeking to intervene, which the court construed quite literally as seeking intervention as a party member than rather a request to represent his client's interests. There can be no plausible tactical reason to argue vociferously to represent and heard on an issue and yet intently choose not to cite the client's Sixth Amendment right to counsel. For support that Ms. Daybell can satisfy the second prong of the Perry fundamental error test, this court can also look at Stavey Boldenbach. There, Boldenbach argued the trial court erred in giving the jury a particular initial aggressor instruction in a self-defense case. His attorney objected to the trial court giving any initial aggressor instruction, which the court overruled, but counsel did not object to the final instruction as worded. The Idaho Supreme Court held that the issue was not preserved, but that Boldenbach easily satisfied the second prong of Perry. The error is clear from the record. It was not a tactical decision because defense counsel attempted to prevent the jury from having the instruction regarding an initial aggressor. So basically they're saying, look, I tried to stop you once. You kept going. You can't say I didn't try hard enough. Kind of is the way I would word it in like other terms. Like in Boldenbach, where trial counsel tried to prevent the court from giving an initial aggressor instruction altogether, here means objecting to the court proceeding with the hearing or the motion to disqualify and trying to intervene to be heard. As in Boldenbach, there can be no tactical reason for counsel trying to prevent the hearing and trying to be heard at the hearing, but then failing to cite the Sixth Amendment. The constitutional right was clear and obvious. It was not waived. There is evidence in the record that counsel did not make a tactical decision to let the issue go. As for the third element, normally the appellate would bear the burden to show that the error affected the defendant's substantial rights and meaning. In most instances, that must have affected the outcome of the trial proceedings. This case, however, is one of the minority instances that is so because the complete denial of counsel at a critical stage is not subject to harmless error analysis. The absence of counsel makes the proceeding itself unreliable. There is no way for a defendant to prove how counsel's presence may have changed the outcome. Structural errors defy analysis by harmless error standards because they affect the framework within the trial proceedings and are not simply an error in the trial process itself. Counsel was not absent for a mere blip in the proceedings or some inconsequential point. This was the hearing that impacted Lori Daybell's fundamental right to choose who she wanted to represent her. The court held that hearing and took argument from the parties, excluding Ms. Daybell's counsel, on August 30th, 2021, which continued September 8th, 2021, so that Chad Daybell could be present, but not Lori Daybell. At the September 8th hearing, it admitted evidence and continued to hear the issue, and then it went fact-finding at an ex parte meeting between the court, Chad Daybell, and John Pryor. At all junctures, Miss Daybell's rights went unrepresented. And again, it's multiple instances. They felt the need to include Chad. She's also incompetent at the time. It is not possible to reconstruct what the outcome might have been had counsel been permitted to actively represent Miss Daybell at this critical point in her case. To be sure, he could have offered his version of the facts regarding the alleged simultaneous representation. He could have argued to the court that Chad's comments at the ex parte hearing should have been given great weight. He could have impressed upon the court the importance of Ms. Daybell's right to counsel of choice, which seemed to get overlooked in the process. The result of the motion for disqualification cannot be said to be a reliable one. As an important interest went unrepresented, there was no way to predict the outcome of the trial had means remained in the case. This court should reverse Ms. Daybell's convictions and remand for a new trial due to a complete denial of her Sixth Amendment right to counsel at a critical stage in the criminal prosecution. Yeah, as I said, it's rough. It's rough because, like, it makes sense, right? Like, people don't like Lori, right? But, and maybe this previous lawyer was actually worse than the current one, but they're having meetings, deciding who gets to represent her, doing it with with Chad, but not her, and she's incompetent, and her own lawyer can't speak. That is just not great. Not a great look. Ms. Daybell was also deprived of her due process right under the 14th Amendment not to be prosecuted while she was incompetent, and her related constitutional right to be physically present at all critical stages when the district court held pretrial hearings in her absence on the state's motion to disqualify her counsel. This issue is similar but independent of the last. Here, Ms. Daybell contends that the district court's decision to route the state's motion for disqualification to Chad Daybell's case, where it actively litigated while she was incompetent in her absence, violated her 14th Amendment right to due process of law. As with the last issue, Ms. Daybell's counsel below did not cite the 14th Amendment as a basis for the court to withhold litigating the state's motion until his client was competent. This court standard of review is again one of looking for fundamental error. The court must review the record to determine whether the alleged error exists, violates one or more of the defense's unwaivable constitutional rights, and was not harmless. Here's the legal standards. Skipping over some of this because it's just going to be case law. All right. For the same reasons that Ms. Daybell gave in issue 2, the hearing on the state's motion for disqualification of her counsel amounted to a critical stage of the prosecution against her. The resolution of those hearings affected her substantial right to counsel of her choice. Applying the first prong of Perry fundamental error test, Ms. Daybell did not waive her constitutional rights to be present or agree that proceedings can occur during her incompetency. She had no choice in the matter. She was found to be incompetent by the court. The court remanded her to the custody of the Department of Health and Welfare. She could not have knowingly and voluntarily waived those constitutional rights in any event. The error plainly exists on this record. There is no dispute that she was incompetent during this trial, during this time frame, and she was not physically present during the hearings on the disqualification of her counsel. As with the last issue, Means attempted to be heard at the hearing. In fact, he expressly noted we need to express our objection to going forward based on the state that is happening. While he may not have cited constitutional grounds, he raised the issues of proceeding in the face of a stay for competency. As Boldenbeck, this is evidence in the record that counsel did not make a tactical choice to forego citing constitutional basis for its objection. Which, I mean, I guess there's an argument, too, that even if he's being tactical here, she is deemed incompetent. So she can't, and she wasn't there. She can't advocate on her own behalf. Ms. Daybell contends as an issue 2 that is placing a burden on her to prove that the error must have affected the outcome of the trial proceedings is inappropriate given the right that was at stake. It is not possible to prove she had been competent and physically present to be heard on the issue. The outcome of the trial would have been different. That is unknowable. And it's true. You don't know how the other lawyer would have handled it. I think she would have been found guilty. I really do, but you don't know. But had the court delayed this hearing, the issue, she was competent and present as it should. She would have been able to express why she wanted Means to continue as her counsel. In assessing the harm from issues 2 and 3, the court should keep in mind that Ms. Daybell's absence and court refusal to allow her counsel to participate in these hearings work together to provide her having a voice on the critical issue of who would represent her at trial. Had one of these been different, then her interests might have been represented. They simply were not. She respectfully contends this court should reverse and remand for a new trial. That one's a lot shorter, but I think it's really all of the mix. All of those ones mix. And this is when we get to another issue. This is an issue that's entirely separate of what we talked about. The district court erred in allowing the state to introduce evidence of uncharged bad acts from Arizona into the Idaho criminal trial under Rule 404B of the Idaho Rules of Evidence. Introduction. Ms. Daybell contends that she was tried as much for her character and conduct in Arizona as she was for the charged crimes. This court should reverse on any of the several grounds related to the admission of wholesale IRE 404B evidence. First, the state gave unreasonable late notice for the intent to introduce evidence from Arizona in this case. Next, the evidence introduced was not relevant to prove plan, preparation, knowledge, and identity. I don't think that's true. I think all of this was part of a massive plan and knowledge, and all of it's connected. So I disagree with that. And instead, it's large propensity or bad character evidence. Finally, even if there was some probable value from Arizona, evidence as to one or more of the IRE 404B factors, the danger of unfair precedents following that evidence substantially outweighs probable value. The omission of the evidence led to the confusion of the issues was misleading to the jury. And there's some case law here. And we'll get out of the discussion. The prosecution failed to provide reasonable notice. When the state initially moved to introduce evidence under 404B, it offered vague generalities. I mean, didn't they take the death penalty off the table for this, right? Am I wrong? Maybe I am. So that's kind of handled, I think. It offered vague generalities to the nature of that evidence. It listed the general nature of the evidence it intended to present, including 24 listed categories of evidence related to Charles Vallow's death, Lori's previous husband's death, and other evidence. I would love to know about her previous husband's death. I would love to know what the state dug up. Anything that made it questionable with Lori. Ms. Daybell objected based on the extensive sweep of the motion, and the district court tended to agree. The state followed up with an amended motion to introduce the evidence, this time trimming the evidence in some ways, tied primarily to the matter regarding Ms. Daybell's marriage to Charles Vallow's casting, the events leading up to and after Charles Vallow's shooting, and the attempted shooting of Brandon Boudreaux. But it was still exceptionally broad. Ms. Daybell again objected to the lack of reasonable notice, citing the broad scope of the evidence and the burden it would put on the defense to investigate, which amounted to a separate case or cases in a different state for a trial that was set to begin in a few short weeks. District Court overruled that objection, distinguished the cases where the Idaho Supreme Court had reversed for sufficient notice on the ground that notice of the cases came at trial, if at all. The District Court further concluded that because the nature of the evidence had been disclosed to the defense over time in discovery, the defense could not claim surprise. The District Court abused discretion in resolving the notice issue adversely to Ms. Daybell. It is true that the state gave notice in advance of trial, but the question is whether the notice was reasonable. It was not. A requirement of reasonableness applies that the notice is far enough in advance of the trial that the defendant has a fair opportunity to prepare and meet the evidence. As such, reasonableness must be assessed in light of the circumstances of the individual case before the district court. This case is unlike any other run-of-the-mill case that contains 404B issues spanned 2 states, was investigated by an alphabet of law enforcement agencies, featured intense media scrutiny, and had 2 precursor felony cases involving 5 prosecuting attorneys and 2 defense counsel with a death penalty team, and was tried 3 years after Ms. Daybell was arrested. The amount of information generated by so many individuals and entities was enormous. It is not reasonable to expect defense counsel in a case such as this to read the prosecution's mind about whether it intended to introduce uncharged misconduct from another state. The nature of this case and the amount of 404B evidence demanded notice much earlier than a few weeks before the criminal trial. As argued by defense counsel below, there is no reason why the state should not have decided much earlier whether it intended to introduce the Arizona evidence. The state has been hiding the ball on this issue for at least a year, 8 months, and 16 days, the time between the grand jury indictment and the proposed date of trial. A reasonable conclusion is that it wanted the element of surprise, which is precisely what the notice requirement IRE 404B2B is intended to avoid. And I guess it's also probably why they keep warning Lori, like, hey, if you keep going. In the Arizona case, may know, let her know, it could come up. Be prepared. You're pushing it. This inference is bolstered by the state's repeated late discovery disclosures, which led to the district court striking the death penalty as a sanction. So yeah, this was what led to that being striked. The district court abused discretion in simply not denying the state's amended motion for lack of reasonable notice. The evidence was not relevant to prove Ms. Daybell's plan, preparation, knowledge, or identity. I disagree with this. Evidence is relevant if it has any tendency to make a fact more or less probable, as it would without the evidence. The fact is a consequence of determining action. IRE 4041, the court allows the state to introduce the bulk of the proffered Arizona evidence under the theory that was relevant to prove plan, preparation, knowledge, and identity, which it claimed were disputed issues. Starting with identity. The Supreme Court has held that evidence of prior misconduct is relevant on the issues of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or pattern between the prior conduct and the charged crime. The quintessential example is when identity is when a material factual issue is a prior bad act or crime and tends to prove the defendant is the one who committed the crime. Is there a signature? Yeah, there is. Calling them dark. Alex Cox. Chad Daybell's involvement. All of it. What sounds like a signature might also involve a woman named Melanie, because there's an open investigation. We'll see about that. That's why a lot of people have posted, anytime Lori brought up, why is Melanie not charged? And it's because when you think of each crime, and you're talking about what happened, and you're watching the trial, you hear a name come up. Melanie. There's a pattern, right? Signature. And, yeah. On the other hand, when the characteristics of both the prior offense and the charged crime are not in any way distinct, but similar to numerous other crimes committed by persons other than the defendant, no inference or identity can arise. This is going to be a dumb argument. You were doing so well in the prior ones. It is true here, for example, the state's theory that Charles Vallow was somehow lured into a trap and shot under the guise of self-defense and is no way similar to the manner in which J.J. Tiley or Tammy Daybell died. Isn't it? Are we sure? Are we sure? I mean, the self-defense, no, but yes. I don't think they use it at trial, but Lori is repeatedly blaming things on Tiley. That Tiley's the problem. She loves to blame things on Tiley. And lure it into a trap. You could argue that the kids were possibly killed in some sort of a trickery to get them in that position so they could be killed without the killing being seen. Planning for the bodies, like there's, they were they had like lying about shooting a raccoon and putting it in the pet cemetery. Like there's trap plotting, whatever you want to word it as. They're focusing on trap, but like the plotting aspect is there. Like Lori's contacting Melanie, contacting Alex, contacting Chad and Charles. They know Charles is coming, and she's having people lie about the whereabouts of JJ and lying about where Tiley is. Like all of this applies. It's a pattern. She does the same thing every time. Let's continue. It also applies to the attempted shooting of Brandon Boudreaux from the back of a vehicle. How are you going to compare someone shooting at Tammy is from a vehicle is not, I think it was from a vehicle, but anyway, shooting at Tammy is not similar to Brandon Boudreaux. Considering Alex Cox, right? What are you doing? Nothing about the factual circumstances of those events give rise to signature that tends to make the killer's identity more likely than without the evidence. Everyone around Lori dies. They get murdered. And it's tied back to Lori. They call them dark, and they get murdered. More removed is how the circumstances which the state claimed were violent crimes in Arizona showed a signature that pointed to Lori Daybell. Knowledge is also misapplied. For this factor to be relevant, the uncharged bad acts must logically tend to show an awareness or knowledge by the defendant of the charged crimes. The shooting of Charles Vallow, in which the state contended was a setup for self-defense, the alleged shooting of Brandon Boudreaux, do not tend to make it more likely that Lori Daybell had knowledge of the murders of J.J. Tiley or Tammy Daybell committed in entirely different ways. I mean, the accusations are that all of them are planning the murders in a vast conspiracy, and that Lori is fully aware of the murders of JJ and Tiley and Tammy, and that actually Alex did the murders of JJ and Tiley, as well as tried to kill Tammy Daybell, and then Chad finished Tammy off, and all of them are talking with Lori and working with Lori. Like, maybe if you didn't know anything about the case, but no. This makes it very much more likely. This would be as dumb as saying... This would be as dumb as saying in a theoretical scenario if Brandon Boudreaux's kids were killed and they brought in him being shot at, and then we're like, well, the kids being killed, you can't suggest that as part of a conspiracy with Lori. She would have been, right, suspect number one. Right. Like, I just listened to a phone call that I hadn't heard before. 911. It was, I believe, the parents of Brandon Boudreaux calling 911 because Melanie and possibly Alex Cox were in the garage trying to enter the home to get Melanie's children at some point after the shooting had occurred with Brandon. Like, how are you saying this stuff isn't connected, right? like all of these things intertwine and should be investigated for those reasons. And you have to see the full picture. That's part of the argument you have in Arizona when people are watching and are so frustrated, and the jury isn't getting the full picture of what happened. Some of this is disjointed. It doesn't make sense because the jury doesn't get it all because they're trying to not be prejudiced, but all of this is connected. Perhaps the closest call would be the defendant's plan or preparation, but the problem here is the state's shotgun approach to the 404B evidence. Some of the Arizona evidence under the state's theory of the case may tend to make the existence of a scheme or plan involving the acts in Idaho more likely than without that evidence. But the most prejudicial evidence, the circumstances surrounding the shooting of Charles Vallow and the attempted shooting of Brandon Boudreaux, do nothing to move the needle. Except they show that there are prior killings and killing attempts that involve the same people plotting, and now we have a new plot. More people died that are connected to them, following a pattern with the same people doing the same dirty work. Explained below carried a high danger of unfair prejudice to Miss Daybell. Rule 403, balancing the probative value of the evidence, was substantially outweighed by the danger of unfair prejudice, confusion of the issues, and misleading of the jury. Even if there was some probative value from the Arizona evidence as to one or more of the 404B factors, the danger of unfair prejudice was extreme. Circling back to where Ms. Daybell began the issue, the state's laundry list of 404B evidence from Arizona, where about 1/3 of the witnesses testified partially or entirely to what the state contended was a criminal activity or bad acts in Arizona, meant that Ms. Daybell's trial was based on a large extent on the 404B evidence. The state was not relying on some concrete judgment of conviction with a few supporting facts sprinkled in. It was essentially trying her for a conspiracy to murder her ex-husband and a conspiracy to murder Brandon Boudreaux. I don't know how much percentage of the trial was focused on that. I can't argue. I didn't watch, right? You'll have to tell me. Crimes for which she had not been convicted, which, by the way, very much could both be convicted by the time this would be retried. The facts had not been established on either of those events, and this created many trials within this trial. The danger from prior bad acts evidence is it allows a jury to convict the defendant because they're a bad person or have a bad character rather than basing a verdict on the facts supporting the crimes charged. It heightens the risk that so much mud will be flung that a jury will decide the defendant must have done something. It risks confusing the issue, what is the purpose of this evidence as opposed to that evidence, and can easily mislead a jury. A trial court should use the care of a surgeon with a scalpel when considering admitting this type of evidence in this type of case, not a meat cleaver. This case was rife with wholesale evidence of bad acts and had character from Arizona. The probative value of the evidence, if any, was substantially outweighed by the danger of unfair prejudice, confusion of the issues, and misleading of the jury. For any of these reasons, the district court abused its discretion in granting the state's motion and attempting the Arizona bad acts evidence in this trial. And here we have the district court erred in denying Ms. Daybell's motion to dismiss based on a violation of her statutory and constitutional rights to a speedy trial. I have heard so much complaining about speedy trials from defendants. I want you to understand. I am jaded. I am numb. I am biased. Okay? I have followed so many J6 cases where the people charged would complain constantly about how long they were in trial or held in jail, and then you look and it was their own side delaying things. And Sarah Boone complained about delays, and where did the delays come from? Her side. I am just so tired of this argument. Because it just feels like every time I look into an issue where some I'm sure there's issues where it doesn't happen, but it feels like every time I look into a defendant that's like, my speedy trial rights were violated. They weren't, and a lot of times the delays are due to the defendant. It drives me crazy. Because a lot of people, at least with the J6 stuff, they delayed to stay in that jail because, and this is from the defendants themselves, that jail, they got away with more than prison. So it was, I don't know. Let's continue. There are perhaps few other cases in which a defendant has so forcefully demanded, I'm going to interrupt again. Someone's going to argue that prison is better than jail, and in most cases, I would say yes. The DC jail, they were doing podcasts, they were filming videos inside the jail of the guards sleeping. They were getting away with so much stuff. It's not a normal scenario. I'm jaded. Let's put it that way. Let's continue. Miss Daybell repeated, there are present a few other cases in which a defendant has so forcefully demanded her right to a speedy trial. She does do that. I'll give her that. From what I've seen in Arizona. Ms. Daybell repeated that refrain early and often. Her counsel noted it frequently in hearings and filings. Ms. Daybell moved to dismiss, claiming that her speedy trial rights were violated due to the 2-year delay between when the state filed the indictment and when she was ultimately tried. The delay was beyond the 6 months required by IC 193501. I can't speak on that. And the time frame generally contemplated by the Idaho Constitution, the Sixth Amendment. The district court erred in denying that motion, and this court should reverse it. I expect this to be extremely weak. Again, I'm biased. There was a defendant's whether there was an infringement of the defendant's right to speedy trial presents a mixed question of law and fact. This court defers the trial's findings supported by substantial competence evidence, but exerts free review of the trial's court's conclusion of law. Standard of law, we're going to skip all that. We're just going to see their main thing that's actually here at the discussion. The state filed its indictment on May 25th, 2021. Ms. Daybell's trial started on April 3rd, 2023, nearly 2 years since the state indicted her. The Idaho Supreme Court had held that a 14-month delay since indictment is presumptively prejudicial, noting that a 14-month delay triggers further inquiry into the remaining 3 Burker factors. A 2-year delay in this case is presumptively prejudicial. In addition, as the district court noted, Lori has never waived her right to a speedy trial, and it's clear she never relinquished or abandoned this right. She was incompetent, though, for part of it, right? It's not the state's fault. Not only did she not relinquish the right, she loudly asserted it. She had demanded a speedy trial at her arraignment. She objected to her counsel request to reevaluate her competency in 2022, which I will say she was found competent again, but competency issues, the state has to take the courts have to take competency issues seriously, or again, we'd be having an appeal. She moved to the court to dismiss the indictment after it had reset the trial for April 2023. Her counsel also repeatedly indicated in statements to the court and in their papers that their client was asserting her speedy trial rights. This factor weighs strongly in her favor. A portion of the delay is clearly attributed to the court's finding that Ms. Daybell was not competent. At least they admit that, to proceed, and on subsequent restoration proceedings at the state's hospital. The court found her competent on June 9th, 2021, staying her case, incompetent on June 9th, and then lifted the stay when they found her competent April 11, 2022, a period of 10 months. While Ms. Daybell concedes that the reason for her portion of delay is not attributed to the state, it is not attributable to her voluntary choice to seek a delay either. At most, it's neutral. She was arraigned on April 22, 2022, and demanded a speedy trial, which was set for the following October. The state quickly filed a motion to continue the trial about 90 days to next January to line it up with Chad Daybell's currently scheduled trial. Okay. I mean, the thing is, I don't know. Again, I didn't watch. I would assume part of that is saying, listen, we want to line it up because the witnesses are the same. It's the same case, essentially. The court found good cause supporting this motion over Ms. Daybell's objection. This sounds fine so far to me, by the way. Essentially, to avoid improper severance of the cases. Right, so they weren't even severed at this point. In October, Ms. Daybell's counsel filed a motion to stay the case and reevaluate her competency. They noted she objected to the motion and also objected to the hearing. The court granted that motion and reset the trial for April of 2023. In November, the court held an evidentiary hearing and found Ms. Daybell competent. It filed the stay, and the trial began on April 3rd, 2023. I mean, there are people that would argue right now that she's incompetent. So, I don't know. Who knows what she was telling that attorney? The overall reasons for the delay, incompetency, placing the case on the same track for the trial, and reevaluating competency do not necessarily weigh in favor of either party. Ms. Daybell personally did not request any of the delays. She objected to them when she could. She did cause them. The final component of the analysis is prejudice. As noted, a 2-year delay that a defendant did not request or acquiesce is presumptively prejudicial. I mean, we're already talking about multiple months of that being 11 months of her first incompetency. Obviously, she was incompetent. Then we're at a couple more months for a month for the second time, but then they had to reschedule the trial. And 90 days of it is to line it up because they were not severed cases. So, we're looking at a delay of a couple months? If you take all of that out? But the court must also look at the particular facts of the case. For Mansfield, the United States Supreme Court identifies 3 interests. While assessing the preventing oppressive pretrial incarceration Barker factor, the district court focused on the time between November 22nd and April 23rd. but it's too small a window of time. Ms. Daybell has been incarcerated since her arrest in February of 2020 and has never left custody. True, she was not technically incarcerated on these particular charges until May of 2021. Yeah, you had multiple cases. But a shift in the paperwork as the basis for holding one in jail hardly matters to the detainee. I don't think it matters to the who's going to be deciding this either. While some of that time was spent in the state mental hospital, that too is but a different flavor of jail. As I said, I didn't think this would be strong. It's getting worse. Oh man. The oppressive pretrial incarceration factor runs in tandem with anxiety and concern of the accused. The court may recall that until right before trial, the state was seeking a death sentence against Lori Vallow. The anxiety and concern of one awaiting trial for 2 years for a trial that could result in the sentence of death must be understandably immense. We're going to get some flavor of this for Sarah Boone. As for limiting the possibility that the defense will be impartial, impaired, Miss Daybell acknowledges that her counsel voiced concern about whether they thought was a shortness of time to prepare. Still, the right is personal to her, not her counsel. All right, just making sure I'm on track here. Overall, in light of Ms. Daybell's repeated and strong invocation of her right to a speedy trial, which reflects her strong desire to see the charge resolved and to avoid prolonged anxiety, oppressive pretrial incarceration conditions, and presumptively prejudiced length of the delay, balanced against the reasons given for extending the time, the district court erred in concluding that good cause has been shown to overcome this fundamental right. The court should have instead dismissed the indictment under IC 19-3501 and it erred in further concluding that Ms. Daybell's 6-minute right to a speedy trial had not been violated. This court should reverse with instructions to dismiss the indictment. Lori Daybell respectfully asks this court to reverse their judgment of conviction and remand for an order dismissing all charges against her based on a violation of her statutory and constitutional rights to a speedy trial. Short of that, this court should reverse the judgment's conclusion to remand for a new trial on the errors raised in issues 1 through 5. I hate Roman numerals. Respectfully submitted 30th of May, 2025. I mean, she's not getting dismissals, I don't think. I don't think that's happening. I could see a new trial, sadly, because of... of course, I'm seeing this as someone who didn't follow the first case, so I'm only seeing it from their eyes. Even with the best view they're giving, the last couple things were bad. I don't think it had anything to stand on. The whole thing with her lawyer being forced out while she's incompetent and not allowed to speak at the hearing and an ex parte thing and all that. As a lay person, maybe it has legs. Maybe that's something that's going to happen. I hate to see it. So let me know what you think in the comments below. Like, comment, subscribe, become a member if you want. Buy me a coffee's down there, whatever. Again, a thank you to Tanika's 2 cents for sending me that email when I couldn't find it. I knew the document existed. I could not find the search for it on the Supreme Court website. I was using Google and I was able to find other parts of this case, but I couldn't find this particular document. She found it. I'm not sure how, at the time of recording, but it's a link to the Supreme Court PDF. I would feel so bad for the families if she gets it. She gets a new trial in Idaho. But thankfully, everything in Arizona so far has been separated. And the fact that she's now seemingly purposefully trying to open the door in Arizona is making a little more sense to me. Thankfully, her being her own lawyer, she's not very good at what she does, and she's making it very clear that she's trying to force that issue, and the state is repeatedly warning her, so even if it gets to a point where they have to bring in stuff from Idaho, they can say it's her fault. She did it. And therefore, hopefully avoid this type of issue on their appeal. She's obviously going to appeal Arizona, right? It's unfair I had the same judge or whatever she does. But hopefully they can dot their I's and cross their T's and prevent any 404 complaining. And again, if you're still here, just so you know, I'm planning to cover the trial Monday, Tuesday, Wednesday, Thursday, and the plan is right now I'm taking Friday off no matter what happens. The only way you're going to get a video updating on the trial is if everything ends before then, and it's verdict watch, and I do a video about the verdict. That would be the only way that you'll probably get a Friday video. On the Lori Vallow case, I thought about delaying this video and putting it out Friday. It's like a filler, but I decided to just put it out today instead. So hopefully you enjoyed and found it interesting and gives you an insight into, because Lori knew this was going on. She knew what's going to be filed in Idaho, right? And also maybe it gives you an idea of the branches that Sarah Boone's people might go for in Florida. We're still waiting for more documents on that, though.